My father is a civil rights litigator, and I got to work with him for a bit. And as I went through the journey of law school and post law school, I found that the kind of work that I want to do was to meet with members of my community and help them preserve legacies. Um, so I include some pictures here. The dogs, just because who doesn't love a picture of a couple cute dogs? I include the picture of the tractor here. That's a 1942 tractor. Um, and estate planning really kind of includes or helps me with my passion for preserving things. So as we go through the estate planning process, sometimes it's these things like a tractor that holds sentimental value to somebody. This was a tractor that was my grandfather's. If he hadn't had his estate plan properly in place, who knows what would have happened to this? Who knows, what fights could have occurred over some of his assets and things that otherwise, people don't necessarily contemplate. What are these things that are personable to members of our family? And then the last picture. So I'm not fortunate enough yet to have kids of my own, but as I look at my own estate plan, I have to contemplate, okay, well, based on my situation now, I need to have something in place that's going to benefit the members of my family in the way that I want it to go, right? So I've got 9 nieces and nephews, no children. So what my plan needs to encompass is how am I going to set up these young children that if something were to happen to me, that they're going to inherit, but they're going to inherit in a way that's responsible. And we're going to get into why there's some reasons and how there's some mechanisms to help ensure that inheritance do not occur too young. Last picture about me. So I do a lot of woodworking. I do wood turning on a lathe. And I show this picture of these pens here that I made for a specific reason. And that reason is that just like every different kind of wood has to be approached in a different way when I'm making them into something because they have different hardnesses, they have different colors to them. So too is every estate plan unique. They're unique based on individual circumstances, whether that's because you're a widow, whether that's because you have 10 children, no children, 2 children that you are very close with, and 1 that's estranged. Every person's situation is unique. And I want you to think about your personal family relationships as we go through this presentation. And I do want you to keep in mind that some things are not applicable to everyone, whether that's because everyone's finances differ. Some people, their assets are wrapped more into retirement plans. Other people, they have a lot of real estate. Other people have numbers or asset levels that are going to put them into a federal estate tax range. All these things we'll go over as we go through this process, but I implore you to just remember that everyone's situation is unique. Now, I'm also cognizant that many of you may be viewing this presentation from another state. So here in Pennsylvania, we have specific estate laws. And these laws, this actually stems from the Constitution. Estate laws are something that the government, the federal government, has kicked to the states, and it's just part of our process. It's that division of states' rights versus federal law. So there are some overarching federal laws, like a federal estate tax that comes into place now when an individual has more than $15 million. But I just say to remind you again that state laws differ. So while you may be coming from a state that does not have inheritance tax, Pennsylvania does. Now that you may have a perfect plan for New Jersey or a perfect plan for Delaware. Not to say that that plan can't translate to Pennsylvania, but it is something that you're going to want to keep in mind, and probably something you're going to want at least some guidance on. Hey, do these documents that were drafted in Maryland, do they directly translate to Pennsylvania? Is this plan that I made in Maryland the best plan based on Pennsylvania's inheritance laws? So speaking more broadly, estate planning is the preparation of documents for the event of incapacity or death. So really what you're trying to do is right now, when you have full capacity and you're able to make decisions about your future, what's going to happen with your assets when you pass, that's estate planning. And we also encompass into estate planning documents like powers of attorney that will help in the event that you become incapacitated. So you're still alive. Your will does not direct until after death. So we need to have documents in place that give someone the right to manage finances or to help make medical decisions in the event that you can't make those decisions for yourself. Something we will touch on a little bit, and it's kind of the overarching backdrop of all this, is estate administration. And that is a process of handling someone's affairs after they've died. Remember, estate laws change by state. And so the real key here with the estate administration is, one, it is a legal process and something that we often see people overlook the fact that when you are administering an estate, whether you're the executor or the administrator, you have fiduciary duties and you have accounting responsibilities to show where assets are going. So this intestate succession is something, we're going to kind of start off with here, which is when someone dies without a will. Every state has different laws and different rules directed by statute that say if you die without a will, these are the people who will receive. So intestate succession, a lot of times, is where you hear those stories of someone inheriting from an uncle they didn't know existed. He might have died without a will, and all of a sudden this person is in line for an inheritance that they otherwise didn't think they would be. The other key here, probably for a lot of your children to discuss, is if they die without a will, does not mean that spouse gets everything. So in Pennsylvania law, and again, it differs depending on what relations of family members are still alive, but the rule of thumb is for sole assets, if someone is married and has children, the surviving spouse gets half of the sole asset, and the children of the decedent, the person who died, gets the other half. There's some nuances there, but it's just something that maybe it doesn't affect you, but it's something to have in the back of your mind when you talk with your family and your friends that, hey, if they don't have a will in place, their spouse doesn't just get everything. The other part of intestate succession is if your will does not have a deep enough roster of beneficiaries, beneficiaries being the people who are set to inherit from you. If the will does not contemplate, for example, if your will might give to your children, and if your children predecease you, then your will says to your grandchildren. If you lack a line there where there are no grandchildren, the state has to find someone where those assets in your estate can go outward to, whether that's to siblings, whether that's to nieces and nephews. One thing I always remind clients of is, this is something you should contemplate, and maybe the state intestate statute is fine with what you want, but really there's a failure of issue means that all the beneficiaries that are named in a will are gone. Sometimes that's a catastrophic event. Maybe it's just because documents haven't been updated well enough. But you can choose through a failure of issue provision who you want to get things if everyone else is gone. A lot of times this is a charity or an array of charities, an array of nieces and nephews. But a key here is, as I look through someone's will and I say to them, hey, just so you know, if all these people are gone, who's set to inherit? That cousin that you said you didn't like, do you really want them to get your stuff? That brother that you just can't stand, do you want him to get your stuff if these other beneficiaries are not around? So it's not the overarching. This is usually kind of the last conversation as with a client, but it is something to contemplate. So talking about a last will and testament. So it's a legal document, and there's directives for how it needs to be drafted, how it needs to be witnessed, how it needs to be signed, and what it needs to be said. So it allows the decedent, which is you, the person who's died is the decedent, to direct who's going to receive their assets and in what proportions. So it might be to my children equally. It might be to this child's going to get 60% and this child will get 40%. The will is your opportunity to direct my assets are going to go to these people in these proportions. Another key thing that the will does is it appoints a fiduciary called an executor to carry out your last wishes. So that means that you're choosing somebody or array of people that you say, hey, I'm going to give you the legal responsibility after my death to make sure that all of these beneficiaries receive what they should receive in the proportions that they should receive it, as well as your executor is tasked with, just the basics, changing title to the house. It needs, as it goes out to a surviving spouse. You're going to have a lot of problems if a spouse dies and no executor ever changes the title of the deed to that sole surviving spouse, because when that second spouse dies, there's going to be a whole host of problems caused for the children's level or whatever beneficiaries there are if you actually have two people named on a title, both of which are dead. One died, perhaps 10 years prior. One thing I want to kind of iterate here is I'm aware of how uncomfortable it is to discuss our own demise. I try to approach this with grace and with an open heart. I understand, a lot of what we're going to be talking about can be uncomfortable, but my train of thought is it's better to contemplate these things now when we have the opportunity than to leave it up to chance when we die. So there's different kinds of wills. As you see here, I've got 3 listed: a simple will, a will with testamentary trust provisions, and a pour-over will to a trust agreement. So taking them in order, a simple will, it suffices for a lot of people, and it's just, hey, upon my death, then these people, my children will inherit my estate in equal shares. Or maybe it actually would probably start, if you're married and your spouse is living, everything to my spouse. If my spouse is not alive, then everything to my children. If my children are deceased or a child is deceased, then that child's children, your grandchildren, will inherit. A will with testamentary trust provisions is just a little bit of a step up. And I almost never recommend that anybody leaves my office without testamentary trust provisions. Testamentary trust provisions it's a clause in the will that says if any beneficiary is going to inherit under a certain age, then their share will actually go into trust, and then we'll define the terms. So a common one here is we say, if any beneficiary is under the age of 30, then their share, if they're going to inherit under age 30, their share will go into trust. That trust will hold that beneficiary share, and at age 25, they'll get the first half of their inheritance. At the age of 30, they'll get the balance of that inheritance. This also allows us to kind of, add in some language, something I call HEMS: health, education, maintenance, and support. So while that share is held in trust, the trustee, who's going to be another party, like a third party, they're able to use their discretion to pay for things out of that trust share for that beneficiary. So maybe I'll make it a little bit easier. We'll just use a grandchild. So in this example, your will contemplates that your child is to receive, you have one child, your child's to receive your estate upon your death. But it contemplates that if your child predeceases you or dies, shortly after you or shortly before you, that child's children, let's say that you have 2 grandchildren from that one child, that child's 2 grandchildren will inherit that child's share equally. But those children, we don't know their age or their responsibility levels with finances. They might be 15 and 17. We're going to want to have that testamentary trust provision that says if your grandchildren are going to inherit and they're under age 30, we don't want them getting essentially half of your estate each, because remember, 1 child, 2 grandchildren. So if we're using an estate that's worth $1 million, I would recommend that your grandchildren who are age 15 and 17 do not get their shares, their $500,000 each, at age 18. Instead, we want to push it into a trust through a testamentary trust provision that says, yeah, it's going to be their inheritance, but we want them to be old enough to be responsible with the money. So again, we're going to use that 25 for half and 30 for the remainder. While it's held in trust, the trustee can say, hey, beneficiary, grandchild of yours, you have this $500,000 set aside for you, but you can't touch it yet. You're not responsible enough, but we can use it to pay for your health, your education, your maintenance, and your support. Health and education, they're pretty straightforward. Maintenance and support can be a bit more all-encompassing. It could be down payments on a house. It could be, rent for an apartment. And you're free to decide, some people want just health and education. These are all things that are free for you as the person person signing the will to have some say into. So the last type of will here is a pour over will to a trust agreement. So a trust agreement, let's think of it as kind of like a trust is a separate holding pot. Okay, so your will is pretty simple. It just says, upon my death, everything to my spouse, or if my spouse has predeceased me, then everything's going to flow to this trust. The trust is a private document, whereas the will is a public document. So a lot of times people are using trusts for privacy or for different uses of restrictions. As we talked about those testamentary trust provisions, trusts can allow for a lot more trust. A standalone trust allows for a lot more play in what the restrictions could be or what funds can be used for. Now, we will talk about trusts a little bit later on, but I wanted to kind of give you a quick overview of that. So a codicil, it's an amendment to an existing will. They've been used more frequently in the past, and the change has kind of come to a certain extent with the availability of word processing. So a codicil, it allows for some simple changes or revisions. Hey, my will failed to mention this other child's name because the child was not yet born. Okay, that makes sense. It's a quick addition to the will. Your original will is still recognized, and the codicil says, hey, just FYI, I'm adding this one little thing to it. It allows for flexibility and potentially lesser fees or legal fees, but I will caution you with this. Sometimes, because you're adding to something, you're going to have the attorney look at what you already have. And so I'm open in saying that if the attorney goes through it and says you really need to redo it, well, you're probably going to be, accruing a little bit of extra work because the attorney had to go through those original documents. They then meet with you and say, hey, there's a lot here that from what you've told me needs to be changed. And the codicil just isn't going to be able to, cure those issues. So talking about powers of attorney, so as I said, powers of attorney are really for use while you're still alive. And that, in most circumstances, they come into play when someone loses capacity. So they've, had a health issue where they just no longer, can make rational decisions. Or it could just be, upon older age, you just need a child to come in and help, or you need someone else to come in and help you manage finances. Unimportant thing to remind you here with any of these documents, and especially powers of attorney, is once you've lost capacity, so once a doctor or honestly an attorney has declared that, like, hey, they can't be making legal decisions. They can't be signing legal documents. And part of my job is when I meet with people is to kind of hash out, does this person, in my opinion, have full capacity that later on down the road, someone's not going to challenge and say, hey, mom was in a rough spot and she was not there. She didn't have capacity to sign this power of attorney to my sibling. That's where a lot of the fighting is going to start, is if you wait too long. and you're kind of scrambling to try and catch up. The other thing to keep in mind here is with any of these different roles, such as agents under a power of attorney, there should be a layer of successors. So if you're married, you would probably name your spouse as the first agent. And then if you have children, you're going to name, children in some form of an order, because what you want to do is contemplate, if my spouse is unable to act as my agent, we want to have these successors that can step in. Much simpler to do this way through a simple document than it is to have to get a guardianship proceeding enacted. So I give you this example. Someone doesn't have a power of attorney and they start to lose capacity. The family says, whoa, we've got to step in and help mom. She's not all there anymore. But mom never had a power of attorney appointing somebody to be her agent. Well, a guardianship proceeding is going to have to be enacted, which is essentially your family asking the court, hey, court, mom has lost capacity. One of us needs to be named as the person that can step in and make decisions for her. Well, that can be tough because, one, the court is having to declare somebody that they need someone else to manage their finances or make health decisions for them. Also complicated by the more people that are involved, right? So one child might think that they should be the person that's the agent or the guardian, and another child thinks that they should be. Well, that's going to end in a court battle. So even one that's uncontested, you have one child and it makes total sense that that child's going to be the guardian. The court is essentially taking away your civil rights in order to appoint that guardian. So it's going to be an expensive process. An uncontested guardianship can, range from $5,000 to $10,000, and there's going to be a layover. So mom has lost capacity. She needs long-term care, but doesn't have liquid assets for it. So the house is going to need to be sold. There's going to be, a couple month layover before the guardianship is actually, followed through with. And the court saying, yes, guardian, you can now sell this real estate on behalf of your mother. It's just having powers of attorney is just a much cleaner and much quicker and less expensive way to get around those. So taking them in turn, financial power of attorneys, general power of attorneys, these powers of attorney go by a lot of different names. But generally, I just call it a financial power of attorney. And that grants someone the ability to step into your shoes to be you financially. Now, they are a fiduciary to you. They owe you fiduciary duties. But you want to pick someone that you trust. So again, it's probably spouse, and then it's probably your children in an order. Could be a neutral third party. But it's somebody that you want to be able to liquidate accounts, sell real estate, do the things that you would need done for you financially to be able to continue with your current lifestyle. Medical powers of attorney, and this one goes by a ton of different names, but the most common is Advanced Healthcare Directive. And really, it encompasses two documents. You've probably heard of a living will. A living will is you with full capacity making decisions for, if I'm ever terminal and laying on my deathbed and unable to communicate my wishes, then I don't want CPR. I don't want a ventilator. It's your opportunity to essentially lay out what you would want. This is a lot of times like a DNR, a do not resuscitate. These should be encompassed in the living will portion of your advanced healthcare medical power of attorney. The second thing that document does is it's going to name an agent to step in if there's anything in that living will there's some procedure that needs to be done that's not incorporated into this living will, maybe because it's just a new medical procedure. Your agent's able to step in and essentially direct the doctors and say, hey, this is what's going to be done based on, I know my mother, I see her living will. Yes, this procedure might not technically fall into that living will, but based on everything I know and based on my decision, she wouldn't want that. So as we transition to trust agreements, they're essentially a contract. And I bring up, I think a very important thing to remember here is, again, state estate laws vary. So that's a tricky sentence. Um, so while trusts are all, can be useful, you have to remember that trust laws and the way that states treat trusts can be different. So I often hear, in Pennsylvania, and I don't want to conflate terms, but probate and inheritance taxes, we're going to talk about that a little bit more. Um, we here, I'm in Kennett Square, I'm on State Street, and I'm, I guess, about 8 to 10 minutes from Delaware. So, I'll often be at a cocktail party and people will tell me about how great trusts are. Well, I have to stop and think and ask them, well, where are you a resident of? Oh, I live in Delaware. Okay, well, then our estate laws differ. Trusts in Delaware are primo, they are king. Um, the problem is that as people, migrate across the border here between Delaware and Pennsylvania, um, the same reason that a trust might be beneficial in Delaware, it may not have the same benefits in Pennsylvania. So that's something I want to just kind of have you keep in mind, is that what we hear commonly, whether it's through television, through the news, trusts are helpful, but they're not necessarily right for every person. What they are essentially is, I kind of discussed this a little earlier, trust is essentially a holding pot for assets. Typically, I tend to think of them as kind of like brokerage accounts. It's something that's an investment tool, and it's, as we talked about earlier, it's something that you can use your will to pour over to. Now, you have to have that trust agreement created before death in order to have it be a full, outlined document, but it allows you to outline restrictions or rules for inheritance, for example, and it gives different distribution terms. Two common misconceptions here. I guess misconceptions might not be the right word, but there's a stark difference between a revocable trust and an irrevocable trust. It's kind of in the name. A revocable trust is something that you can freely change, you can freely update, but it gives a lot less benefits. So an irrevocable trust is something that you're drafting and you're signing and you're saying, hey, I am relinquishing the rights to this property, and it's unchangeable. So irrevocable, cannot revoke it. It's set in stone once it's signed. Those assets that are put into it, you're going to have someone else will have to be the trustee, and essentially you're giving up ownership of that ownership rights in that property. Irrevocable trusts are a huge benefit for federal estate tax purposes. So, like I said earlier, the federal exemption, which keeps, it changes year to, every few years. The big beautiful bill has just raised the exemption for individuals to $15 million. What that means is every dollar over that 15 million, you're going to get taxed at probably around 40% on the federal level. This is not the state level, this is the federal level. So under 15 million, zero inheritance tax from the federal government. Over 15 million, 40% tax on every dollar. So irrevocable trusts are often a way for people to push stuff out of their estate and say, hey, I recognize that I'm going to hit this tax level, so we're going to push stuff out of the estate, whether it's by gifting or putting into an irrevocable trust, to help us avoid that 40% tax. Just another friendly reminder here that state laws change between states, which includes rules and laws regarding trusts. And again, this is kind of reiterating what I had said with, there's a lot of misunderstandings, a lot of misinformation, and it can vary vastly between states. Talked about the federal state tax exemptions. It's $15 million per individual. It's a high number. Trusts used to be, it used to be, I think, 600,000 Many of you might remember those days when the trusts were a lot more prevalent, because as these as different bills come out and they're set to sunset and then they get reenacted, that federal estate tax exemption has always gone up. And I think I know the reason why. It's because this comes from legislation. The people signing this legislation are our congressmen. And I would wager to say that they don't want to see, a lot of them don't want to see the estate tax exemption come down. So who knows what it will be by the time that I'm ready to retire. But right now it's $15 million per individual. Obviously, for a married couple, that makes it 30 million. But there are key steps. So if you're within that range of 15 to 30 or anywhere there above, really, if you're above 10 as a married couple, there's something that we want to talk about. There's something you're going to want to get in front of an attorney and just have them look at your assets and make sure that one, upon the death of the first spouse, that we elect the portability, which is basically saying, hey, my spouse didn't use up their exemption. I would like to add it to my exemption. Give you a quick story here. Oftentimes people come to me and they're under the range. They've done their own research and they say, well, I'm not within the federal estate tax level. I'm close, but I'm not there. And this is me speaking for someone else. I wish I was within that level. But oftentimes, as I kind of flush things out with the client, and I say, well, okay, I see you have real estate that you're valuing at, $1 million, but where is it? And when was that last valuation done? Oh, it's just a wooded patch of woods up in northern Pennsylvania. I bought it, 40 years ago for $100,000. I just figure, at this point, it's probably worth 100. Well, there could be reason for us to get an appraisal or for us to look at it, because when it comes time and you decease, you die, what you thought was only $1 million property could actually be appraised or valued at 5 million. So you went from thinking you were under the level to, all of a sudden these assets are worth more than you thought that they were. I've seen it occur in reality, both for good and for bad, where somebody, didn't get ahead of it. And I've helped clients get ahead of it in order to stay away from that incredible amount of tax that comes from the federal government. So some other considerations for trusts, this could be for creditors, for spousal or special needs protections. I want to kind of take those in turn. So creditor protection, it could be because your beneficiary is going to be inheriting and you think, oh, shoot, I know that they have some debts. Well, as soon as this inheritance reaches their bank account, oh, shoot, that creditor's probably coming looking for this money that they're receiving. Another consideration would be, you might have a child whose spouse that you don't trust. And that doesn't mean you don't like them. It's just they might not be financially wise. When let's say you have a son that's going to inherit, $500,000. Well, that $500,000 hits his bank account, his joint bank account that he shares with his wife. That is, for all intents and purposes, money that she can then use. Now, if she doesn't use it wisely, he can't get it back. A trust can be used, again, where it's something that you're giving to your child, but there's certain restrictions on it, whether it's that it's held solely for them or there's some kind of third party that needs to come in to approve expenses. But it's just something to keep in mind if you have concerns, either about that child themselves or the child's spouse, that they're going to use the money unwisely. Special needs or extenuating circumstances. So something that's often overlooked is if somebody is slotted to inherit, whether they're the direct beneficiary or they're a contingent beneficiary, meaning if child dies, then to child's child, i.e. your grandchild. If they're on government assistance, for example, and the threshold, I believe, is $2,000 is all they can have, or else they get kicked from government assistance programs, whether that's, maybe they have special needs. And right now, a lot of their health care is being provided by the state, or various expenses, housing expenses are being provided by the state. Well, if they end up inheriting directly from you a large portion, even if it's only over that $2,000 limit, it will kick them off of that government assistance. And now what you intended to give down to your grandchild or your child will now be used to pay for those same government assistance programs or assistance programs that they otherwise qualified for, but now their inheritance has booted them from. So that inheritance will have to be used up for those same services, and then they'll have to, essentially reapply and get back on government assistance. Can be easily cured by just having a conversation with an attorney and figuring out, this is something wise, and maybe it's even just a provision that we keep in a trust that says, if any beneficiary ends up having a disability of some sort and they're on government assistance, then instead of them inheriting directly, a special needs trust will catch that inheritance. We'll move on from that. Something that's always overlooked, and maybe I should have started with this, is that designated beneficiaries win over wills. What that means is that if the title to your house has, it's jointly titled with your spouse, okay? Or it's jointly titled with somebody. We'll use spouse just for ease here. No matter what you put in your will, the deed's going to override. So I guess the example, actually, let's use this. The example here is a brokerage account. Your brokerage account, it has, it's a vast portion of your estate. You've got $1 million in there. You have John Smith named as the designated beneficiary, but your will says to Jane Doe. Maybe you opened the account 20 years ago. You were best friends with John Smith and you weren't. You didn't have anybody else, and you thought, if I die right now with my $10,000 in this brokerage account, not realizing how much it would grow, you have John Smith named. But your will, which was done more recently, says Jane Doe. Well, the will doesn't matter there. It's whatever the account is designated as, that flows outside the will. That can work in some pretty crazy ways because people forget to update these things, and they forget to, or they're just never wise, never told, hey, this is actually going to trump your will. Something, and we'll actually talk about this right here next, is this per stirpes designation. Per stirpes, and I'll draw this back to the designated beneficiaries here in a minute, but per stirpes is a Latin term. It looks like it's per stripes, misspelled, but it is not. It's per stirpes. And it essentially is a designation used in a will or on a designated beneficiary that says that if that person, that beneficiary is going to inherit and they predecease me, or they die, very close to me, then their lineal descendants will take that share. So that is where, the example here is my house to John and Nancy. If Nancy dies before me, only John gets my house. Note that there's no per stirpes designation there. Second example here is my house to John and Nancy per stirpes. What that means is that John will get his half, but if Nancy has died before me, her children get her share. Common misconception here is the idea that if your child dies, that their spouse will just inherit. That is not true unless you designate it as so. If you have a per stirpes designation, it would be your child if they predecease you, not to their spouse, but to the children. Remember, that's where we can wrap it in with a testamentary trust provision, and maybe that spouse is the trustee of the grandchildren's trusts, But what it does is it frees up, instead of giving all that money to the or that inheritance to the surviving spouse of your child, you actually, I often caution people against this. You might love that spouse, but remember that your child has died, and there's reason for her. Let's use a male and a female here. Your son has died. He has the best wife ever. We love her. We think she's great. They have children together, and everything's swimming. There's no fights, no nothing. Problem is that she still has a whole life to live, and she may remarry, or she may change and become a different person. She remarries, that inheritance that you had slotted for your son, but you said, hey, if son dies, then to his wife. Well, that's now hers. She's free to do with it what she wants, which also means that if she remarries, that becomes probably marital property for her new marriage. Well, she might, this new husband might bring his own children into the marriage, and maybe she predeceases him. Well, he has no obligation to your direct grandchildren to give them anything. And or he could be terrible with finances. So in my view, it's always better to have a per stirpes designation where you're leaving it to the direct lineal descendants, because at least it's going to at least go to your direct descendants. Now, there's always reasons. Sometimes there's extra, different circumstances where you just say, nope, if my child is deceased, then I do want their spouse to get the share. The caveat, or not the caveat, but the flip side there is with that testamentary trust provision, your grandchildren are receiving those funds held for them in trust. Maybe their mom is the trustee. She's able to access that money for the use of your grandchildren, but it is not her direct money. So that's kind of one of the ideas here of where testamentary trust provisions can be king. So circling back up on this slide is the designated beneficiaries. So oftentimes I have clients furnish me their beneficiary designations on accounts, and I would say 90% of the time it lacks a per stirpes designation. And what I mean by that is maybe the primary is your spouse, and the contingents, the second level, so 100% to my spouse if they survive me. If not, then equally between my 3 children. What's missing? Per stirpes, right? So we're saying to my children, and it ends there. Well, it should say, if this is what you want, to my children per stirpes, so that if 2 children survive and 1 does not, instead of now it's just being split between 2 children, you add in that per stirpes designation after the name of each child, and that child's children receive what their parent would have received. I don't have any tattoos, but if I ever got one, it would be per stirpes, because that is a term that is just underused and undervalued. Again, I kind of harken back to the beginning where I said, this can be uncomfortable, and part of my job is bridging the gap of uncomfortability with reality. So your estate plan should address a lot of what ifs. I kind of live in a world of what if. What if that child does not survive you? Do we have provisions that say what's going to happen with those assets for their children? What if these people don't survive, or what if your estate comes down significantly or raises significantly? One of the what ifs I often talk with people about is they want to leave something for a charity or their church. A lot of times in wills that I've seen drafted from others is people want to leave a flat number. So they want to give $25,000 to the church. Okay, no problem. Why can't we just have that as a percentage instead of a flat number? You can use it as a percentage. So what I mean by this is, if we're looking at the value of that $25,000 in your current estate, it's going to be different from the time that you pass, whether your estate has gone up or gone down. But that $25,000 might end up being a huge portion of your estate. So what you had thought, you have $1 million and you're leaving $1 million to your child, your one child. Well, okay, we'll take 25,000 off as a specific bequest to the church. But what happens if you end up in long-term care and your $1 million estate is down to 100,000 at the time of your death? Well, that 25,000 is going to have such a much more significant impact on your estate than it would when you drew up the documents and that you had $1 million. Instead, let's find some percentage where that 25,000 makes sense, so that if your estate goes down, you're not discounting your heirs by such a significant portion. Now, of course, it can go the other way. We have a percentage and you win the lottery. Well, it's probably right that you give the church more than 25,000. You just found $1 billion from a lottery ticket. But if you're using a flat fee, a flat number in that specific bequest, 25,000 is it. Remember, you're gone. You can't, hand over more money. The will says 25,000 to the church. You died with $1 billion. Sorry, church, it's all you're getting. Now this, I don't know how many of you have cryptocurrency, but something I always try and reiterate with folks is it's always good to have fresh minds or a fresh set of eyes look at your documents and look for things that hadn't been contemplated at the time that they were drafted. Cryptocurrency is one of those new things that's causing a lot of problems where people's wills don't address something like this. And so money's getting, things that have value, and cryptocurrency is a whole conversation in and of itself, but for all intents and purposes, they do have value right now. And a lot of older wills just don't mention them, and it can cause problems with who actually owns this upon my death. The one that gets me a lot is, I don't know how many of you have a Facebook or different social media platforms, email addresses, these kinds of things, but your will and your estate plan should contemplate who's going to get ownership of these things. The failure of a will to identify, or the failure to not even have a will, is why we can see problems where people are using someone who is deceased's email address or social media, and it can cause all kinds of problems because, truthfully, we don't know who owns it unless we say who's going to own it upon our death. And just reiterating here, lastly, is a key consideration is what are the responsibility levels and ages of beneficiaries, and do our documents contemplate that? Do they contemplate that if something happens to my child, my grandchildren are going to inherit, and they are young, or they're not responsible with money? These are things that you really should think about having cured in your documents. So I want to kind of just touch on this briefly. This is a whole nother state administration and trust administration is a whole different presentation. I could have spent 2 hours on planning and 2 hours on administration, but for time purposes, we're gonna keep it short here. And I'd like to make some time for some questions, but for all intents and purposes, the estate administration is the legal process of actually following through with last wishes and making sure that assets are retitled properly, that debts are paid, credits are paid. Now, like I said, it is a legal process, so it's not always necessary that you hire an attorney or that your heirs hire an attorney. It is something that we advise at least having some input in, because it is a legal process through the court, and there are fiduciary duties, and there are a lot of opportunities for things to go wrong, and someone is ultimately going to be held on the hook for the same. I guess we'll touch on inheritance taxes. Like I said, in Pennsylvania, there's really no avoidance of inheritance tax. Between spouses, there is technically a tax. It's 0%. But again, that comes into what I was saying, where even though everything from your will might transfer to your spouse, you still want to at least consult an attorney to make sure that assets are retitled properly. Um, and, truthfully, something that I see a lot is um, there are priorities to debts. So oftentimes people come to me and they've started the estate administration from their parents' estate by themselves. And, okay, what's the first thing you did? Oh, we paid off the credit cards. There's a priority to debts. You didn't need to do that. Oftentimes, especially for smaller estates, there's ways to kind of negotiate, pennies on the dollar. But there's going rogue, trying to figure out yourself isn't always the wisest, and usually it costs more money than if you just had someone who knows what they're doing kind of step in and aid in the process. So I'm going to take some questions. I just will couch it with this, that everyone's situation is different. I am not giving legal advice here. I am educating. And without a deep dive into your current documents, your current situation, your asset levels, I can't get too specific on what might affect you.
Great. Thank you so much. We've had a little over 20 questions come in. So why don't I
Okay.
start to read a few of them to you? You may be able to say you've really discussed it or just give a quick answer, but I'll start with the first one. I heard that if I were to set up an irrevocable trust, then any assets in that trust would be sheltered from PA inheritance tax. Is that correct? And could you elaborate further?
So yes and no. Again, this is where I don't have a view of your trust. There are ways to shelter from some estate taxes, but I don't want to get too involved in whether your trust is sheltering from Pennsylvania estate taxes.
Okay. And then someone said we need to redo our trusts and other legal documents. Will we need to redo them if we move from Maryland to Pennsylvania? If so, are there any substantial differences in estate laws, powers of attorneys?
So, kind of as I said earlier, it's not a exact question, exact answer. States recognize to an extent the estate laws or the estate documents of other states. And I want to touch directly on your powers of attorney. Powers of attorney are statutory documents, and most often, well, really the only use for them is with institutions, and those institutions have their own, legal departments. So your Maryland power of attorney might be valid, but you might get some kickback from, PNC Bank, which is headquartered in Pennsylvania, and um, it's hard to say without seeing your documents and seeing what they provide. But um, you know, I hate giving. I know I'm giving a non-answer, and I hate it. But it's kind of a roll of the dice if you're moving from another state. More than likely, good portions of it will be fine, but there are opportunities where maybe a state says that you can't do that.
What is the price range for a will with a medical financial power of attorney and also for a trust?
So this is a little tricky. So um, it's going to depend on situation. It's going to depend on how much you need. I have been of mind to move more towards flat feeing. But again, there's going to be a whole different price range based on individual circumstances. Usually this is cured, and I'm able to tell somebody after, during the initial consultation, hey, you're going to be in this range. But I don't want to throw out numbers because for some person it might only cost $1,000. For another, it might end up being 10,000 just because there's so much involved.
We get asked a lot about the Pennsylvania inheritance tax, so I'm not surprised there's a lot of questions about this. And this person was asking, how can we ensure we have enough money to last our lifetime and not also burden our children with the inheritance tax?
So Yeah, this is where things often get tricky for folks. Inheritance tax, remember, is a percentage. So for children's line, it's or any lineal descendant, it's 4.5%. So if your child is inheriting $1 million, basically what occurs is whatever they're receiving, they pay 4.5% on, as opposed to them having to like put up 4.5% in order to get that inheritance. We took that $1 million, but if we had $100,000, they'd be in line to get the 100,000 minus 4.5%, where that really becomes tricky. And I think this is probably where this question kind of stems from is illiquidity, not having liquid funds enough in an estate is when, for example, real estate needs to be sold. There's different methods, like I guess in theory, if a child really wants to keep the house, they could take out a loan to pay the inheritance tax, and essentially their inheritance is the house. But yeah, I hope that answers that. But
Yep.
it's a tax. It's not a you show up with the money and then we'll give you money back. You just need to work with somebody to make sure there's enough liquidity there. And when there's not, sorry, there's a big old truck. Um, when there's not, that's usually when, like real estate and other assets have to be sold off.
Another question, how does failure of issue work in an irrevocable trust?
Failure of issues, it's just you deciding, again, you're just making a provision that says if all of these beneficiaries have passed, then this is the who else, right? So we've gone with the children per stirpes. We're doing this descendant line. Well, maybe that is where if the descendant line dies, then we're giving to this other group, this other class of people, or this charity, that kind of stuff.
Who controls what trusts are invested in?
So trusts are who controls what trusts are invested in. So there's usually a trust holder. So the trustee is the person who's essentially on the hook for the asset. So let's take something where, let's say I'm the trustee. It's my role to make sure that those funds, let's say we're taking $100,000, go into this trust. Well, I'm going to work with a financial advisor or someone that I trust that's going to manage the money safely. So really, it's the trustee's job, and the trustee is free to hire legal counsel, accountants, financial advisors, but ultimately it's the trustee who's on the hook for if that money disappears.
And a couple questions about power of attorney. This one said, does the age of the power of attorney matter? And the example was that the person had one for her father or his father that was about 10 years old when I needed to use it for some financial changes, and the bank questioned how old the POA was.
Yeah, so that's a really good question. Like I said, POAs, powers of attorney, are driven by statute. So as new legislation comes out and that statute is updated, technically old ones should still be active, but really we're relying on the institution. I've dealt with a lot where, hey, this is technically an active POA. It's missing the statutory language. This is where things really become a problem because I'm relying on my convincing of, PNC Bank's legal department that like, guys, this is active. We can use it. So I think the last change to the statute was in 2018, where they made some like serious changes. So there's something you want to kind of look at. And I can understand why an institution would say, whoa, this might be a little bit too old.
Does a power of attorney need to live locally?
No, no. In today's day and age, a lot of things are done electronically. It could help if they need to do stuff with real estate, or there's assets or reasons for them to be local. But for all intents and purposes, I mean, I've seen people with agents that live outside the country. I've seen people with agents that live, in California. Maybe there's a reason that they need to travel out here every once in a while, but usually it's the document itself that allows them to act wherever they are.
And this person says we're healthy, but at what point should we assign a financial power of attorney? Can it be conditional under certain health circumstances? And do we need to appoint each other for financial powers attorneys for things like our IRAs and 401ks?
Um, is that one, did you select that as answer? I just want to actually read it
I
while
just
I
put dismissed.
dismissed. Okay, hold on. Okay, at the moment we're both healthy, that one. So um, yeah, there's kind of two options here. Powers of attorney can be, quote, springing powers of attorney, which essentially have language in there that conditions the use of the power of attorney on the principal you being declared incapacitated. Um, Not always the best way to go about it. In fact, most attorneys say springing powers of attorney shouldn't be used because there is such a hurdle to get over in order for the agent to actually act. Because a lot of times, the reason for an agent to act is that they need to act quickly. Um, the other option here, and it's not perfect, but you can essentially create a springing power of attorney by not giving the general power of attorney to the agent until they need to use it. Um, a common example is sometimes clients, so there's an agent acknowledgement page that has to be signed by the agent in order for them to act. It doesn't need to be signed at the same time. So it's basically like an addendum. Um, so oftentimes clients will just ask me to hold the whole packet. I have their power of attorney. I hold it until either one, I learn of their incapacity, or two, they direct me to send it to the agent. So it essentially accomplishes the same goal.
And who can act as your power of attorney if you have no family or person to designate?
Yeah, anybody. So you can name, it's a role that has to be accepted. In theory, you could name, George Bush. It doesn't mean he's going to act. But oftentimes you'll see some services, whether it's an attorney, whether it's a institution that will accept acting as a power of attorney, accept being, appointed. Usually there's for compensation, and in most powers of attorney, there's a clause that allows the agent reasonable compensation if they need to act on your behalf. But third parties, they don't have to be family. You got to pick someone you trust, or someone that is in a position of trust.
And then a good question for us, someone asked, does Kendal require these documents? And yes, when you're getting ready to move into the communities and sign our life care agreement, we do ask to get copies of your advance directives and living wills because your intention is to be here the rest of your life, and we may need to have access to those documents in the future. So we would ask for them at that time, much closer to when you're moving in. How about why is a durable power of attorney so important?
So the durable, it's the financial. It's called a durable, a general. Um, Very important because you're trying to avoid the guardianship proceeding. So something occurs to you and you need somebody to, again, like sell off real estate in order to pay for health costs or so forth. Once you've lost capacity, there's no signing or appointing an agent then. The only way to go by doing it is through a guardianship proceeding.
Here's a good one. Where should you keep your will? Your desk, a safety deposit box, give copies to your children?
Thank you for asking this. I will tell you, do not put it in a safety deposit box. So, powers of attorney cease to be active upon the death of the principal. What that means is you could name, let's say you've got your will names John Smith as your executor, and John Smith is also your power of attorney. Legally and technically, if your will is in a safety deposit box and you die, John Smith is no longer your agent under your power of attorney because it ceases to be active upon your death. he's going to have a heck of a time being able to get into that safety deposit box to get your original will, which the original will is needed to be filed with the Register of Wills. Depends on the attorney. Some attorneys will offer to hold your original will. Some do not. It needs to be somewhere, wherever it is, it needs to be somewhere where key people know of its existence and where it is. Hard to say based on individual circumstances where it should be, but there should be an original somewhere. And I would also say a copy should be somewhere else, whether that's with your attorney, just for in case the original is lost or God forbid destroyed. And there's a presumption under Pennsylvania law that the inability to find a will means that it was actively destroyed by the person. They said, I don't want this will anymore. It's gone.
Great. I think we have time for just a couple more questions. If you're in memory care, are you considered unable to manage your affairs?
Probably. It's hard to say. I would assume like you're in memory care. It's kind of outside my realm here. Is if you're in memory care, my assumption is you've been in some way declared incapacitated or unable to manage your affairs.
Let's see. What happens if the person is a solo ager with no spouse or children or siblings that could be financial or medical guardian? How can a fiduciary be set up in case of incapacity? Kendal requires this. Can an attorney be appointed? What is the cost of the estate for this, for example, or how does it work?
And I just want to, is that one
It's towards the bottom.
In the dismissed column or?
No, I can put it there if you want me to.
Yeah, if you don't mind, just so I can pull it up easier.
It'll be at the bottom now.
There. Person is a solo ager with no spouse or children or sibling that could be a financial or medical guardian. Attorneys a lot of times are appointed as fiduciaries in that circumstance, usually for financial or executor roles. Really not usually for medical. There are like separate companies that offer, but like my stance, for example, is unless you are my direct family medical, I'm not going to accept an agency for, just because it's too attenuated, and I don't want to play God. I don't want to make decisions for someone's physical well-being. But on the financial side, it's pretty regular that there are either institutions or attorneys who are asked to do that role.
If you don't purchase the life care contract and one spouse needs skilled nursing, how do you protect retirement savings for the other spouse to meet living expenses and potentially that spouse's medical care?
Is that in? Can you put
I just put it there now.
Thank you. Hold on, I'm not seeing it. If you don't purchase the life care and one spouse needs skilled nursing, how do you protect retirement savings for the other spouse to meet living expenses? I think they're using the term life care.
I mean, I can answer from our side what they're saying. If they were to come here, they're covered even if they run out of money. Our life care contract takes care of people the rest of their life. So this person is saying, if I don't come to Kendal and now my spouse needs care and I'm worried, about the cost, I'm assuming they're asking maybe about Medicaid or other programs like that.
Yeah, I think it's a bit of a nuanced question that I don't really want to dive in too much without further info because
Okay.
Trust can be used sometimes. But I don't really want to dive into this one too closely.
Okay. Let's see if there's anything else in here. A lot of them are very specific questions, so I'm concerned about going into those. Here's an interesting one. If your husband had a child years ago that you didn't know about until after he died, how does per stripes, however you say that, apply to the situation?
So he had did assuming well, it would not be your child
Right.
because you didn't adopt them. So if he died and everything transferred to you, you owe that child nothing. They're
Okay.
not, per stirpes is your direct lineal descendants, not someone else's. So if your child had another child, that you didn't know about, that child is technically caught by that per stirpes designation.
All right. I think this will be our last question. I'm considering naming a financial management company as my power of attorney. Was there any thoughts you had about that?
Just look at expenses. Look at reviews on that company. Usually they have like a graduated these third parties like trust companies and financial management companies. A lot of times they have, graduated fee schedules. Attorneys typically operate on just hourly work, 6-minute increments. Um, so, it's something to certainly consult someone with, but it's hard to say whether you should use that financial company or not.
Well, thank you so much. I think this has been such a wonderful presentation. I know there's
Thank
a
you.
lot more questions coming in, but I think we are kind of running short on time here. I'd just like to remind everyone who participated, we will be sending you a thank you email, and in our March newsletter, you will receive a copy of the recording of this presentation, so you'll be able to look back on it. And thank you again. Thank you for everyone who attended today. Have a great day.
Thank you so much.